Good evening. Welcome to the webinar. This webinar is on enduring powers of attorney. My name's Jacqui Brauman. I'm the Principal Solicitor at TBA Law and an accredited wills and estate specialist. So as well as having done my qualification to be a lawyer, I've gone and done a master's degree specifically in wills and estates, and then done a 12-month program with the Law Institute to be accredited. So what I'm going to do is share my screen so that we have some slides, and I then won't be able to see the chat box. Okay, so at the end of the webinar, I'll go back to the chat box and look for any questions. Now you should be able to see my screen. So, as I said, enduring powers of attorney. So they're a really important tool in estate planning, particularly these days with people, I suppose, not, dying suddenly in their 60s. A lot of people are now living into their late 80s and 90s and even into their hundreds, and that comes with loss of health, sometimes loss of mental capacity as well, with dementia increasing. So powers of attorney are becoming more and more important. And look, the other thing is that our lives are getting more and more complicated as well. We're no longer in the 1950s where we have pretty vanilla sort of families, and we also didn't have really complex business structures, but it's becoming more and more common that we have blended families and complex business structures. So a little bit more about me. Yes, I'm a lawyer, obviously. I've talked about my accreditation process. TBA Law is my business. I have another couple of solicitors who work for me as well. We have various locations throughout Victoria. And there's another photo there in the lower corner. That's what I do in my spare time. I really like to fish. It's a way of getting away from the computer and the phone in some respects, getting out into nature. That's my fur baby and my husband. And we do that as often as we can. Now, I've sort of touched on this a little bit as well. Estate planning these days, like I said, is no longer what it would have been in the 1950s. There really isn't a simple will anymore. Yes, family situations can be simple and the will may appear simple, but the process and what we think about is not simple. The extra things that need to be considered, it's great if it comes out as a simple solution, but the strategy itself is not simple. And as part of estate planning, there are all sorts of strategies that we can use to protect the estate against claims. Powers of attorney come into this as well, and appointment of medical treatment decision makers, advanced healthcare directives so that people actually know your instructions about your healthcare. Superannuation is now a huge asset. It is generally not covered by your will. You need to consider binding nominations on your super. We consider trusts in wills. The most simplest form of a trust in a will is a minor's trust. If you leave funds to someone who is under 18, it automatically sets up a trust. But there are other more complex trust structures that we consider depending on situations. Life insurance and total and permanent disability insurance. These are things that we talk about. It's not something we can organise for you, but we definitely talk about your level of debt and the level of debt that you want to be leaving for your family, or whether you've got enough insurance to make sure that there is no debt. If there are young children, instructions to guardians are important. And then we come into other entities with looking at family trusts, family companies, other structures, business structures or investment structures that are around the family. These need to be looked at. Quite often they're also not covered by a will, and often not by a power of attorney as well. They have their own rules. We need to look at those and make sure that the control is handled properly. A personal list of gifts is something that quite a lot of people want to do about, their heirlooms and jewelry and bits and pieces. Memorial instructions are quite often important to people. And all of this needs to be done in the context of what is actually in the estate. So we look at what the property is and the structure of the ownership, and sometimes that needs to change as well. So I suppose this is all done in 2 appointments, and this is something that through our questioning we determine in our own minds, going through with the experience and the checklist that we have, what information we need to get from you. It's not something that you need to come in overly prepared about. We'll be able to guide you through the process. So, case study. I like to use Modern Family because most people will have seen the Modern Family series or reruns of the Modern Family series. And the main patriarch of that family is a great example. He has 2 adult children from his first marriage. He's divorced. He's married Gloria, a much younger woman, who has a young son that is living with them, and then they've had another baby as well. Now, Phil is quite established himself. He has a fairly substantial business. He has about $1 million in super. He's done pretty well. The house is in his name only. He's paid out his ex-wife. There's nothing left there that has to be done. So I've spoken previously about what he does in terms of his will. He needs to also think about what he's doing in terms of a power of attorney. So he's got a few things that are going on. He's still obviously running a business. So if he appoints someone as a power of attorney, they need to have some savviness around the business. He also runs a self-managed super fund. He needs to make sure that someone's savvy enough to be following the investments there. And he has to maintain a young family still. So there still has to be enough income made available for his family and children. So what he decides is he needs to have Gloria involved in the decisions, but she can't be the primary person. She's not business savvy. He certainly wants to make her the primary decision maker in terms of his personal decisions. So she has solely the decision-making capacity around his personal and lifestyle decisions. For financial and legal decisions, he appoints a combination of all 3, Gloria, Cameron, and his daughter. Sorry, forget her name at the moment. So all 3 of them. His daughter's been involved in his business. Gloria needs to have a say around the financials. And Cameron's a lawyer, level-headed, understands the obligations probably more so than the others. So all 3 of them have to act jointly in relation to financial and legal decisions. So that's what he's done there. He's also made a couple of directions. So firstly, there is a direction that his attorneys can act as a director of his company. So all 3 of them jointly can act in his role. And there's a direction there that they can renew any binding nomination he has done on his super fund, but they are not allowed to amend it or change it. So people that are appointed under a power of attorney automatically can't do a will. Now, a binding nomination in some respects is like a will because it's directing a certain amount of assets after someone dies to certain beneficiaries. So we do not want anyone else having any power around that. So that's how he's decided to manage the family dynamic and the importance around making sure that the superannuation is protected, but still workable, and the business will continue to run. His family will continue to run, and Gloria has the say over his children when it comes to his life. So, bearing all that in mind, let me now go into a little bit more detail about the duty and obligations of someone appointed under a power of attorney. So, firstly, this is an enduring power of attorney. So, it works while you're alive, it finishes on your death. It is enduring because it endures past you losing capacity. And in fact, the main purpose of this document is to deal with your loss of capacity. So in fact, Phil in the previous case study says that his only begins in the case that he has lost capacity. So it's not triggered until there's a medical certificate to say that he's lost capacity to make certain decisions. So once that's triggered, and using the power of attorney and the medical certificate, there's obviously fairly stringent duties and obligations on the three that are appointed. So they have to act in accordance with the best interests of Phil. They cannot act in any situation that would involve a conflict. So this can be quite tricky because they're all close family members and beneficiaries of his estate. They can't be taking a benefit from it while he's alive. Excuse me. However, Phil has obligations to maintain his family. So obviously Gloria still needs to be receiving funds from Phil through the power of attorney. Now, the power of attorney will authorise that. The document itself will allow that to happen. And the legislation allows it to happen within reason as well. But that's another reason why we've put in Cameron and the daughter as well jointly with Gloria, because you can see if Gloria was acting alone without the oversight of the kids, they might think that she's doing something wrong. And there's nothing that they could really do about that except take her to VCAT and have her account for what she's done, which will start causing a lot of problems. So let's just have them in there at the first to protect that family dynamic and to protect Gloria as well, so that she's not accused of having a conflict of interest. So powers of attorney, the attorneys appointed can't mix funds with the funds of the person. They have to keep really detailed records of what they're doing, what they're paying for. If they use cash, and I always advise clients to try and avoid using cash, you have to keep detailed receipts of everything that is spent. So it's best to do things either via internet banking or using the FPOS or credit card, so that it's all through the bank statement. Try not to do cash at all. Those, I suppose, are the main obligations. They cannot benefit from the role. They cannot put themselves in a conflict situation. They must act in Phil's best interest. They cannot marry or divorce him. They cannot make a new will for him. And as I said, under the power of attorney, you can put conditions and restrictions on what can be done further as well. So Phil did put a few in there. So there you go. Those are the primary duties and obligations, and those are the things that need to be kept most in mind for attorneys who are acting. There's a whole lot more information out there, and I can provide information sheets if anyone needs them. You can contact me. The Office of the Public Advocate is a government body that provides a lot of this sort of information as well, so you can get a whole lot of pamphlets from them. That's the Office of the Public Advocate. So, while power of attorney documents are a fantastic and really vital tool in the estate planning kit, I suppose you can say, they also sometimes enable elder abuse. So that is why the person making the power of attorney needs to think clearly about who ends up in the role of attorney. Joint appointments are often very valuable in protecting against elder abuse. Also, the consideration about when the power of attorney actually begins and putting in conditions and restrictions. So all of these things are vital in thinking about doing the document, and that's why the document has become more and more complex. We don't want a simple one-page power of attorney anymore. In fact, they're no longer allowed to be, because the attorneys actually need to sign acceptance pages these days, and the people witnessing the document have to be quite highly qualified to even allow a document to be made. Now, the flip side, I suppose, of elder abuse is family members accusing the attorney of elder abuse when there is none. So again, that's why it's really important that the attorney knows their duties and obligations and, to be frank, covers their ass in acting in that role. So no gifts to yourself. That is also why I generally have the power of attorney not even begin until capacity has been lost. I've had a horrible situation where a power of attorney said that it began immediately. However, the person had not lost capacity yet and was still operating her own funds and giving gifts to family members herself. She made numerous gifts to the person she'd appointed in the power of attorney. Quite a number of her family members were estranged and then accused, after she lost capacity, accused the attorney of stealing from mum. He couldn't prove that they were gifts, so there was an order against him to compensate and repay the money, which was quite tragic. And another, I suppose, example of elder abuse was another person that I came across where she had, in fact, appointed both her daughters jointly and severally, though, so they didn't have to act together. One was in Sydney and the other one lived locally near her mum, so was the one doing most of the caring. However, unfortunately, this woman had a gambling issue and gambled away mum's life savings of a couple of $100,000. And this happened before the legislation change. So the police had to go through the process of charging fraud, which is quite a difficult thing to have done, which is why in 2015 the legislation has actually been, I suppose, upgraded to include specific penalties against attorneys for stealing and the ability to make compensation orders as well. So that, I suppose, adds an extra level of protection to the person making the power of attorney, knowing that there are checks and balances within the legislation now too. The problem is that who is going to pull the attorney up? So again, it comes down to the family dynamic. Who is going to act as the police person over the attorney if there's really no one else in the family to oversee it? And occasionally this might end up being a social worker. If mum ends up isolated with no money and social workers become involved, they might start questioning, well, how has this happened? But sometimes that's the only solution. So the estate planning process. Generally, people begin at the bottom of this triangle feeling quite stressed and uncertain and overwhelmed about potentially the process. They don't necessarily want to think through all these difficult things. They think they have to prepare far more than they actually do. So they can, if they start the process, start feeling like it's all very hard and quite exhausting. Now, what I really hope for people is that they skip those first couple of steps, do their research with me, and that's partly why I do these webinars and have lots of information on the website, and I am openly available to answer questions. So people start exploring what they need to do. When they actually get started and realize that working with us is easy, they start feeling proactive and that it can really be done quite quickly. We generally only take 2 weeks to get this whole process done. And then certainty, control, feel protected at the end of the process. It's something off the list of things to do, and peace of mind. So as I said, we generally take 2 weeks to do this process. So it's a 5-step process with us over a 2-week period. You make an appointment with us. We email you some initial information so you can prepare. You don't have to complete all of that. It just starts getting you thinking about what we may need. The first appointment is when we gather all the information from you. So whether you've pre-prepared some or we get it all at that appointment, that's fine. If there are some things that you don't know or are missing at that first appointment, that's fine too, because we just draft the documents with highlighted bits in them for stuff that's missing, and we get that from you before the second appointment. So after the first appointment, like I said, we draft everything, we email it to you. If there's anything else we need, we tell you that we need that, so that by the time of the second appointment rolls around, we have everything ready to go, to be printed and signed. And it's all done at that second appointment. So you have valid documents after 2 appointments. Then we just finish off any other little bits and pieces that need doing, submitting your binding nomination to your super fund, getting your attorneys to sign acceptance pages, and then we submit the final plan to you in the form of a pack of certified copies so that you have those at home. And we have a free service of keeping all the originals if you want us to. Otherwise, you can take them wherever you like. So it's not hard, and I don't want people to be held back by thinking that it is. If you're not willing to jump straight into a full estate planning process, you're not ready to go, you can have a family situation review done with me. So that cost gets rolled into the whole of the estate planning if you do choose to go ahead. But if we review your whole situation and current documents and realise you don't need anything done, then that's the cost, $450. But in fact, for those who watch this podcast and ring the office and mention that you've seen the webinar, not podcast, you can have that family situation review for $295. All right. So that's the special deal for those people who actually watch some of my stuff, particularly all the way through, because if you stop watching halfway through, then you miss out on the offer. So $295 if you mention that you've watched the webinar. All right. So this webinar is actually being quite short and sweet. Thank you very much for attending. As I said, you can email me directly from my email, which is on our website, Meet the Team. My contact details are there, or messaging us through Facebook. You can do that too. I'll see those messages. So I'm going to stop sharing my screen now. I'm going to go back and check whether there's any questions. But I'm going to stop the recording here because anyone watching the recording later doesn't need to see the questions that arise. So stop share. All looking pretty quiet in terms of questions anyway. So I'm going to end the webinar there, and some questions might pop up in the next 5 minutes or so before I cut the webinar off. So again, my name was Jacqui Brauman. Thank you very much for attending, and I hope you have a great evening.